Learned magistrate on an evaluation of the evidence led by the parties in support of their rival cases bracket open rest while husband refuted all the allegations made against him by the divorced wife in the petition and contended that he is not liable to pay any amount as claimed by the divorced wife in her application on the ground that she has obtained divorce under the Dissolution of Muslim Marriage Act 1939 bracket close awarded rupees 60,000 to the divorced wife as reasonable and their provision for future livelihood bracket open. Learned magistrate arrived at that amount basing his conclusion that the monthly income of the husband is rupees 3,000 per month and towards reasonable and fair provision the divorced wife is to be given 1/73rd of his income for a period of 5 years bracket close stop. Rupees 3,000 has been awarded by the learned magistrate towards maintenance for the period of iddat stop para. Fact that the divorced wife had obtained divorce under the provisions of the Dissolution of Muslim Marriage Act 1939 and the main thrust of the argument is that as the dissolution of marriage was brought about by the wife under the Dissolution of Muslim Marriage Act 1939, the decree under the said act did not amount to divorce by the husband because marriage was dissolved by operation of law stop. Learned counsel submitted that a divorced wife is entitled to claim from her former husband reasonable and fair provision for future livelihood under section 3 of the act only if the divorce proceeded from her rest while husband and the divorced wife is not entitled to claim fair and reasonable stop para. It is common ground that the respondent ex-wife filed an application for dissolution of the marriage under the provisions of the Dissolution of Muslim Marriage Act 1939 and a decree for divorce has been granted to her dissolving her marriage with the revision petitioner stop. I may repeat that the contention urged on behalf of the revision petitioner by his counsel with all the vehemence at his command is that as the husband had not divorced the wife by pronouncing talaq bracket open talaq when it becomes irrevocable puts an end of conjugal relationship which subsisted between the parties bracket close and as the wife obtained a decree for dissolution of marriage under the provisions of the Dissolution of Muslim Marriage Act 1939, that is, as the divorce is not the act of the husband and as the dissolution of marriage was brought about at the instance of the wife under the Dissolution of Muslim Marriage Act 1939, the decree for dissolution of marriage does not amount to a divorce stop.